matters. Snehal Batra, Managing Attorney at NPZ's Raritan office is here. Welcome, Snehal. Kem છો તમે?
Hi, Vijaya. Majama chu. Tame kem cho and kem cho to all our listeners.
Very good. Thank you and welcome. So, Snehal, one of our listeners called in and they had a tricky question which I thought I'd pose to you. And they asked if they can sponsor their spouse's child for a green card, and will that mean that they have to adopt that child?
Sure. So this is what we call like the stepchild situation, right?
Mm-hmm.
And this is not too common in our Indian community, but we do see it. And yes, if you are a U.S. citizen or a lawful permanent resident step-parent, then you can petition for your stepchild to immigrate to the U.S. If the step-parent married the stepchild, their birth parent, before the child turned 18 years old. You're
Okay.
not required to adopt your stepchild to petition for them. So there's no separate or formal adoption process that needs to take place.
Mm-hmm.
Immigration recognizes this relationship to be able to convey that immigration benefit. So for immigration, as long as the marriage between the U.S. citizen and a step-parent and the birth parent takes place before the child turns 18, the child is considered a stepchild and the relationship is established. And in that case, the stepchild actually is treated the same way as a biological child.
Uh-huh.
So if you are a U.S. citizen and your stepchild is under 21 and not married, then the immigration considers them to be your immediate relative, meaning they're not in that family preference quota and an immigrant visa is available to them, immediately.
Uh-huh.
It's not just adding that child's name to your spouse's petition. As we know, the immigrant petition requires a separate I-130 for this stepchild, and you file for your spouse and your stepchild if you want to bring both of them to the U.S.
Mm-hmm.
Now, if the child is over 18, let's say when you marry their mom or dad,
Yeah.
then the child is not considered a stepchild, and you can't sponsor them. So this could be problematic, and put families in difficult situations. Also, especially if your spouse-to-be has more than one child and the
Mm-hmm.
child, obviously different ages, somebody's under 18, somebody's over 18. So, you really have to consider all these things, and timing is crucial because of the age of the child when you get married.
Uh-huh.
So, it's always something to look at. And
Yeah.
then, if, let's say, the child is not considered the stepchild, what happens?
Yeah.
When you sponsor your spouse for the green card and they immigrate to the U.S., now they're green card holders, okay? They can then petition for their child, right? If they are
Right.
under 21 or over 21 but unmarried. So there
Right.
could still be a possibility of sponsoring this child.
Mm-hmm.
And of course, if there's a divorce or separation or maybe death of one of the parents, then the stepchild relationship has ended. There are some exceptions, however, if you can show that you've maintained a relationship with your step-parent, after the divorce or separation.
Yeah.
So in order to prove the relationship, you're going to need the marriage certificate. If there's any prior divorces or death of the biological parent, you'll need that death certificate.
Uh-huh.
And then the birth certificate of the stepchild.
I
So
see.
those are some documents. So, if you know somebody in this situation or considering a marriage proposal where there are children, from previous relationships, keep this in mind about the cutoff dates and the ages.
Yes.
So it's best to consult with us so we can help you bring, both your spouse and their children, your stepchildren, to the U.S. if it's possible.
Correct. So much to consider and difficult situation there, but thank you for shining the light on that, Snehal. And of course, the best counsel and representation in immigration law, that's the NPZ Law Group, and they're just a phone call away or the click of a mouse away. All you need to do is to log on to visaserve.com or call them at 201-670